All right, the hurricane forming named Milton has pushed the Sarah Boone case. The judge just announcing it a few moments ago that jury selection process, which was going to be starting this morning, has been pushed until next week. Let's watch the judge.
Thank you so much for letting me know your positions. As we just discussed, as of 10:46 this morning, the chief judge has decided to close all courthouses due to Hurricane Milton, both Wednesday, October 9th and Thursday, October 10. The court anticipates that operations will return to normal on Friday, October 11th, but that's due to the court's continued close monitoring of the impacts of the storm. Due to the potential storm and the ramifications of it, the court is going to postpone jury selection in this matter till Monday, October 14th at 9 a.m. Mr. Owens, please provide the court the order with regard to the clothing and shoes, and we'll address that as necessary. As also requested, please provide my judicial assistant your cellular telephone numbers before you leave today. With that, the court is in recess, and we will see you all on Monday, October 14th. Thank you.
Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, I began with that update right off the bat because that is really the most important thing. Jury selection and her trial has been postponed 1 week. Remember what Judge Cranick said? Only an act of God? Well, it's an act of God, and Hurricane Milton is the culprit. So we do have that happening next Monday, and of course you guys know I'm near Orlando. I'm 30 minutes from Orlando. I live in Central Florida, so I'm deep in the impact of this hurricane incoming. It's a lot up in the air right now about what's going to happen. So I do appreciate everyone's thoughts and prayers for all of us here in Florida, because we are going to take a hit one way or another. So let me go through these updates on her case, and I do want to read the actual order when he denied last week the motion. Remember, he did it came out on Friday, and I hadn't gone over that yet. So I figured this is the perfect opportunity to go over it, because this may be the last video I do for a few days. Because tomorrow I may have to evacuate, because I do live in a mobile home. So again, there's a lot up in the air. Before I get into the motions and the docket information that's up there, I'm going to go through all that. I did also want to note the other big thing that happened this morning, besides the postponement of the trial, is that Sarah Boone rejected a plea offer from the state of Florida. She was offered 15 years for pleading guilty to manslaughter. As far as I'm concerned, that is one of the dumbest possible rejections she could have made. Because remember, back in the beginning in 2020, she was offered 12 years, which she should have taken at the time. She's been in jail for, it'll be 5 years in February, okay? So if she would have taken this plea, I don't think she would have been in jail for maybe another, 4 or 5 years. So I think she's going to learn to regret that particular decision, or misstepping, as it may be. All right, so here is the docket. I did want to go over first, get caught up, like I said, because really, there's not much else we can do until Friday. Well, really Monday. There may be some stuff happening with filings and such between now and Monday. But again, because jury selection doesn't officially begin until Monday now, the 14th. So this was the final decision on the motion to suppress the defendant's statements at the Osceola County Sheriff's Office. Remember the whole interrogation thing that we heard last week? Obviously, I posted it in the community tab, and it was denied, which I'm happy about, and most folks are as well. It's a 10-page order, so I'm going to go through it pretty quickly here. This cause came before the court on October 2nd, 2024 on the defendant's motion to suppress defendant's statements e-filed 9/24/2024, the motion on the state's motion to strike defendant's motion to suppress statements at OCSO and state's response to defendant's motion to suppress statements e-filed 9/27/2024, the response on the defendant's amended motion to suppress defendant's statements at OCSO, e-filed 9/30/2024, the amended motion, and on defendant's second amended motion to suppress defendant's statements at OCSO, e-filed 10/2/2024, the second amended motion. It's a lot of wording. The court, having reviewed the motion, having reviewed the response, having reviewed the amended motion, having reviewed the second amended motion, having reviewed the court file, having considered the testimony and evidence offered by the parties, having considered the arguments offered by the counsel for the state, and having considered the arguments offered by counsel for defendant, finds as follows. A. Defendant Sarah Boone is charged by way of an information filed 3/23/2020 with a single count of second-degree murder, which brings to mind, you remember, they just offered her 15 years for manslaughter. Again, the stupidity, in my opinion, the stupidity by rejecting that plea offer this morning, it just boggles my mind. B. On February 24th, 2020, defendant called 911 after finding her boyfriend, Jorge Torres, deceased. C. Deputy Kayla Rodriguez arrived on February 24, 2020 and spoke to defendant. C also states Exhibit 1. D. Detective Copasol, a homicide detective with the Orange County Sheriff's Office with 6 years experience as a homicide detective and a law enforcement officer since 2023, was the lead investigator of Jorge Torres' death on February 24th, 2020. Detective Copasol arrived at the scene within 30 minutes to 1 hour of OCSO. Deputies arriving, was briefed, and performed a walkthrough of the apartment. Therefore, a search warrant was drafted. E. Detective Copasol then made contact with defendant outside of apartment for a few minutes and explained procedures of the search warrant. The search warrant was executed with CSI. Defendant's cell phone was collected after CSI documented the scene. Detective Copasol wanted to go through the defendant's cell phone to corroborate defendant's story. Defendant signed a consent prior to the February 24, 2020 interviews addressed below. See also Defendant's Exhibit 1. Detective Copasol did not look at defendant's cell phone, including any videos, prior to the interviews addressed below, as digital forensics did not arrive until approximately 7 p.m. Detective Copasol then made contact with defendant's ex-husband, Brian Boone. Therefore, Detectives Copasol and Lowen had an interview with defendant in Detective Copasol's unmarked Nissan Pathfinder at approximately 5 p.m. See also states Exhibit 1. Detective Copasol explained that she wanted to have a conversation with defendant after walking the apartment. Detective Copasol testified that she would not have interviewed defendant outside of the unmarked vehicle, had no memory of using the words routine, and that everything was explained on the recording. The word routine is not used by the Detective Copasol in any recording. See States Exhibit 1. Again, I believe that's another one of Sarah's words that she likes to toss into the mix. F. Detective Copasol explained the purpose of this interview, including defendant's prior conversations with Deputy Kayla Rodriguez and Detective Copasol, and Detective Copasol's desire to get a further understanding of what happened last night and ask defendant more detailed questions. See States Exhibit number 1. Therefore, Detective Copasol began reading Miranda as follows. Detective Copasol, I'm going to read you your rights, but it's just because that's how we do things, okay? So you do have the right to remain silent, okay? Do you understand that? Defendant, yes. Detective Copasol, anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one can be provided for you before questioned without charge. Has anyone threatened you or promised you anything to get you to talk to me? Defendant, no. Detective Kopasal, do you understand what I just read to you? Defendant, yes. G. Therefore, Detective Kopasal interviewed defendant again after the initial digital recorder's memory was full. A second separate recording was initiated. Detective Kopasal confirmed with the defendant that no additional communications occurred prior to the second separate recording, and Detective Kopasal inquired of the defendant prior to asking any other questions. Do you understand that you don't have to speak with me if you don't want to, correct? To which the defendant responded, yes. So again, I believe she completely understood every bit of this. H. After concluding the interviews, but before leaving, Detective Kopasal had conversations with the defendant about coming to OCSO the next day to address the pending autopsy, and that Detective Kopasal would have more questions. Detective Kopasal did not recall speaking about defendant's cell phone, but had defendant asked about getting the cell phone back, Detective Kopasal would not have given a specific time frame for returning defendant's cell phone. Detective Kopasal had no memory of receiving a call from the defendant on the evening of February 24th, 2020. And of course, as we know, that's easily proved. I. Defendant's testimony largely agreed with Detective Kopasal's testimony, including the timeline of calling 911, speaking with Deputy Kayla Rodriguez, and speaking with Detective Kopasal. As to the February 24th, 2020 interviews, defendant confirmed that Detective Kopasal explained that general questions would be asked. Defendant confirmed that she stayed on the scene 10 plus hours while the investigation was performed. Defendant's own testimony was that she was under the influence of alcohol from the night before at approximately 1 p.m. or I don't know if that's 10 p.m. 1 p.m. the next day. It should be 1 p.m. I suppose. It's a little odd how he writes his times on his response. However, there was nothing evidencing defendant being intoxicated or under influence of alcohol when clearly speaking and interacting with Deputy Kayla Rodriguez. See State's Exhibit 1. J. Defendant's statement of making a call to Detective Kopasal between 9:30 p.m. and 10 p.m. on February 24th, 2020 from her ex-husband's home does not line up with defendant's own timeline of staying at the scene 10 plus hours, which began at approximately 1 p.m. The court finds this statement lacks credibility. There you go. K. Defendant claimed that before they left the scene, Detectives Kopasal or Lowen would return defendant's cell phone to the apartment. On February 25th, 2024, defendant claims that defendant and Detective Kopasal had a discussion regarding the picking up of the defendant's cell phone, specifically that due to Detective Kopasal's pregnancy, defendant needed to come down to OCSO to pick up the cell phone. Defendant's sole reason for traveling to OCSO was to pick up the cell phone. The court finds defendant's statement regarding picking up the cell phone also lacks credibility. A lot of what Sarah has to say lacks credibility. L. On February 25th, 2020, after Detective Kopasal reviewed some of the extraction of defendant's cell phone by digital forensics and attended the autopsy, Detective Kopasal requested defendant to come to OCSO office. Detective Kopasal did not want to approach defendant in front of her child at her ex-husband's home. Defendant's worry and concern about her son was addressed with Deputy Kayla Rodriguez. See also State's Exhibit 1. M. The state and the defense agreed that the February 25th, 2020 interview was custodial. N. The pith of defendant's argument is contained in this exchange during the beginning of the February 25th, 2020 interview. Detective Kopasal, just let us know if any time you need water, okay? I'm going to have you sit in the green chair. Detective Kopasal, appreciate you coming in. Defendant, yes ma'am. I want to ask about these when we have a moment, referring to her prepared written questions. Detective Kopasal, sure. So obviously he received his autopsy, so I'm going to read you your rights again because we have to talk about that, and since I'm talking about the incident, we just have to do it, just like we did yesterday. Defendant, normal protocol. Detective Kopasal, just like we did yesterday. Remember, I read you the rights? Defendant, yeah. Detective Copacel, yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? Defendant, sure. Detective Copacel, all right, so you have the right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during questioning without charge. If you can't afford a lawyer and want one, one will be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Defendant, no. Of note, there are footnotes. He's got documented all throughout this. So if you haven't looked at this, I do recommend it. Again, it's on the community tab if you would like to read the actual documents, because sometimes it's hard to read them, I know, on the screen. Okay. Detective Copacel, and do you understand what I just read to you? Defendant, yes. See State's Exhibit 1. All right. Whether the Miranda warning was sufficient. Oh, the Fifth Amendment of the United States Constitution and Article I, Section 9 of the Florida Constitution both provide for a right against self-incrimination. Rigertink v. State 66, Southern 3D 866-887, Florida 2011. The self-incrimination clause of Article 1, Section 9, Florida Constitution requires that prior to custodial interrogation in Florida, suspects must be told that they have a right to remain silent and that anything they say will be used against them in court, and they have the right to a lawyer's help, and that if they cannot pay for a lawyer, one will be appointed to help them. Trailer v. State 596, Southern 2D 957-966, Florida 1992. P. Both the Florida Supreme Court and the United States Supreme Court have stressed that there is not talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed. Miller v. State, 42 Southern 3D, 204-221, Florida 2010. A court does not examine a Miranda warning as if construing a will or defining the terms of an easement. ID at 222, quoting Duckworth versus Egan, 492, United States 195-203, 1989. Rather, the inquiry is simply whether the warnings reasonably conveyed to a suspect his rights as required by Miranda. Alterations in original, quoting California versus Prysock, 453, United States 355, 361, 1981. The crucial test for determining whether police gave a proper warning is whether the words in context used, considering the age, background, intelligence of the individual being interrogated, impart a clear, understandable warning of all of his rights. Quoting Coyote versus the United States, 380, F2D, 305, 308, 10th Circuit, 1967. Q. The Miranda warning provided by law enforcement to defendant at the beginning of February 25th, 2020 interview is sufficient under both federal law, see Florida versus Powell, 559, United States 50, 59 through 60, 2010, quoting Miranda versus Arizona, 384, United States 436, 479, 1966, and Florida law, see Thomas versus State, 351, Southern 3D, 197, 201 through 202, and 204, Florida 1st DCA 2022, and State versus Owens, 41 Southern 3D 352, Florida 5th DCA 2010. R. The Miranda warning given to defendant in the instant case is identical to the exemplary Miranda warnings issued in Owens Supra. S. As such, the Miranda warning given to the defendant in the instant case was sufficient. I feel like I want to boldly underline that. 2. Whether the defendant's statements on February 25th, 2020 were coerced. T. To establish that a statement is involuntary, there must be a finding of coercive police conduct. Baker v. State, 71 Southern 3D, 802, 814, Florida 2011, quoting Schwertwetter v. State, 931 Southern 2D, 857, 867, Florida 2006, Generally, to determine whether a confession is involuntary and coerced, a court must examine the totality of the circumstances surrounding it. Martin v. State, 107 Southern 3D 281 298, Florida 2012. When the voluntariness of a confession is in dispute, it is the state's burden to prove voluntariness by a preponderance of the evidence. Harrell v. State, 390 Southern 3D 610, Florida 2024. There were no misrepresentations of the law regarding any defense. See Johnson v. State, 268 Southern 3D 806 808, Florida 4th DCA 2019. No quid pro quo. CID. No directly or specifically made promises. CID. No overt act or threat of force against defendant was proved or claimed. C. Wyche v. State, 1987, Southern 2D 2326. Florida 2008. No fear of material or physical harm. See Grant v. State, 171 Southern 2D 361 363. Florida 1965, quoting Denmark versus State, 116 Southern 757 759 1928. No hope of material award. No indication the defendant was a newcomer to the law based on the 2 times Miranda warnings were provided between February 24th, 2020 and February 25th, 2020. See United States versus Watson, 423 United States 411 1976. No indication that defendant is mentally deficient, especially considering the verbiage she used. No threats, delusions, deceptions, or promises. See Martin v. State, 107 Southern 2D 281 298, Florida 2012. And defendant was offered water and breaks. See Chavez v. State, 832 Southern 2D 730 749, Florida 2002. There were no false statements made by law enforcement in order to coerce defendant to go to OCSO's office on February 25th, 2020, based on the findings above. Under the totality of circumstances, defendant's statements on February 25th, 2020 were not coerced. Another one that should be bolded and underlined. 3. Whether the defendant's statements on February 25th, 2020 were voluntarily made. X. A statement is not compelled within the meaning of state or federal law if an individual voluntarily, knowingly, and intelligently waives his constitutional privilege. See Miranda v. Arizona, 384, United States 436 444, 1966. The state must prove by a preponderance of the evidence that the defendant's Miranda rights were waived. Barger v. State, 923 Southern 2D 597 601, Florida 5th DCA 2006. To constitute a voluntary waiver, the state must show 1. That the waiver was the result of a free choice on the part of the defendant and not the product of intimidation, coercion, or deception. And 2. The waiver was made with a full awareness of the nature of the right being abandoned and the consequences of the abandonment, CID. Only if the totality of the circumstances surrounding the interrogation reveals both an uncoerced choice and the requisite level of comprehension may a court properly conclude that Miranda rights have been waived. Why? Factors relevant to consider include 1. The manner in which Miranda rights were administered, including any cajoling or trickery. See Miranda, 384 United States at 476, Brewer v. State, 386 Southern 2D 232 237, Florida 1980. 2. The suspect's age, experience, background, and intelligence. See State v. SIW, 465 Southern 2D 1231 1232, Florida 1985. Quoting Fair versus Michael, 442 United States 707 724-25 1979. Dorr versus State, 383 Southern 2D 905 907, Florida 1980. 3. The fact that questioning took place in the station house. See Drake versus State, 441 Southern 2D 1079 1081, Florida 1983. And 4. The fact that the interrogators did not secure a written waiver of the Miranda rights at the outset. See Slinney v. State, 699 Southern 2D 662 669 and 10, Florida 1997. Trailer versus State, 596 Southern 2D 957 966, Florida, 1992. Z. The Miranda rights were administered in a normal tone and cadence. There was no rushed or urgent speech. See Chafin versus State, 121 Southern 3D 608 614, Florida 4th DCA 2013. There was no delay in the administration of defendant's Miranda rights. The recorded February 25th, 2020 interview reflects that the defendant understood and acknowledged that she understood her rights. See State's Exhibit number 1. Defendant acknowledged that she understood her rights. See Slinney v. State, 699 Southern 2D 662 668, Florida, 1997. Evidence supported conclusion that defendants voluntarily waived right to remain silent and obtain counsel when officer read defendant his rights and asked defendant whether he understood each of his rights, to which defendant responded affirmatively. AA. The court reincorporates its findings and herein which further show no cajoling or trickery. BB, defendant was 42 years old at the time she made the statements and appears to be of normal intelligence. See also footnote 2 above. CC, the February 25th, 2020 interview did take place at OCSO's office and no written waiver was secured. DD, under the totality of circumstances, defendant's statements on February 25th, 2020 were made with a voluntary, knowing, and intelligent waiver, and this waiver was the result of a free choice on the part of defendant and was not the product of intimidation, coercion, or deception, and that the waiver was made with full awareness of the nature of the right being abandoned. Ordered and adjudged as follows. Done and ordered. Michael S. Kranick, Circuit Court Judge. Yeah, and I think there's a certificate of service, which is, I did not include that in the uploads. You can only upload 5 pages to the community tab, so I had to upload it twice. But that is his order. Remember, I said it went up Friday that the motion was denied. So that answered all of our questions on that. Let's see here. Let me go back up to the top. All right, so here is where he put here, per the court comment, state placed the offer on the record, defendant rejected offer, jury selection postponed until 10:14 at 9 a.m. So again, she rejected the plea offer, and she's due back in court next Monday at 9 a.m., October 14th. Unfortunately, I'll be in training at work, so I cannot go to the trial now, which is a huge bummer. But I will continue to cover it here, obviously, guys. Let's see. Court minutes. Get caught up here. Comments, defense to provide. Order to allow defendant to wear dress shoes. I guess she wasn't allowed to wear dress shoes today. I heard there was an issue with her and her clothes this morning. But, you know, it's Sarah Boone, so there's always an issue with something. And there was a state's motion in limine to exclude the battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force. So I'm going to go through that real quickly here. The motion in limine. And mostly this stuff here is the experts. He granting the experts protective order. All that sort of stuff. So this was filed 10/6, which oddly enough was Sunday night, 8:22 p.m. This is a state's motion in limine to exclude the battered spouse syndrome evidence or exclude mention of the battered spouse syndrome evidence until the defendant testifies. So this is the state basically saying that until Sarah testifies, there's no evidence of this battered spouse syndrome. I don't think there's evidence of it anyway, and that state obviously believes the same, but she needs to get up on the stand to even use it, and they're trying to make sure that that is the case. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. Introduction. The defendant has filed a notice, an amended notice of her intent to rely on battered spouse syndrome evidence in this case. So that was what was filed on the 4th. So that's back here. So they had filed, on the 6th. So this is their reply. There's so many filings in this case, I swear. It gets me confused sometimes. I know I'm not the only one. So on the 6th, Owens filed that he wanted to use the battered spouse syndrome. So this is the state coming back saying, okay, you can use it, only they want to make sure the judge says only if she gets on the stand. So this is what they're trying to make sure happens. Battered spouse syndrome is actually not a defense to a crime. The introduction of battered spouse syndrome evidence to support a self-defense theory is not for the purpose of justifying a defendant's misperception of reality or to explain why an unreasonable belief was nonetheless justifiable due to her condition. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why the defendant's actions were reasonable. To show, in spite of reasonable perception of danger from the battering spouse, the battered defendant would remain in the home with her batterer, where she may resort to the exertion of force against him to prevent imminent death or great bodily harm. And there's some references to case law. I'm not going to read them because I just read all those from the judge, and I don't know, my tongue is really tied now, guys. Facts. The defendant has presented several accounts of what happened on February 23, 2020. She made a 911 call at approximately 1 p.m. on February 24, 2020. She spoke to a patrol deputy on body-worn camera shortly thereafter, provided a statement to detectives a few hours later on February 24, 2020, and provided a second statement to detectives on February 25, 2020. The defendant retained Dr. Julie Harper as one of her battered spouse syndrome experts in 2020. Over the course of the next several years, Dr. Harper interviewed the defendant about the events of February 23, 2020, multiple times. Exhibit A at the hearing on this motion will be Dr. Harper's deposition, which was taken on October 1st, 2024. The state would direct the court to pages 35, 36 through 39, 41 through 42, 44, 47 through 50, 52, 54 through 56, 66 through 67, 80 through 81, and 95 of Dr. Harper's deposition for the defendant's statements about February 23, 2020. The state retained Dr. Tanya Warner as its battered spouse syndrome expert. Dr. Warner evaluated the defendant on October 2nd, 2024, and Dr. Warner was deposed on October 4th, 2024. Exhibit B at the hearing on this motion would be Dr. Warner's deposition. The state would direct the court to pages 75 through 79 of Dr. Warner's deposition for the defendant's statements about February 23rd, 2020. The state is not asking the court to make any credibility determinations about the defendant's statements to the doctors. That would be for the jury to do, in the full context of a cross-examination with the defendant's statements to law enforcement. What the state is asserting is that as a matter of law, what the defendant told the doctors does not entitle her to a self-defense instruction, nor does it entitle her to introduce evidence of prior instances of violence, reputation evidence of the defendant's violence, or battered spouse syndrome evidence to help the jury understand why what she did was objectionably reasonable. The defendant told the doctors that because of past violence between her and the decedent, she had a generalized fear every day that the decedent would cause her serious bodily harm or kill her. However, on this particular day, the decedent did not take an overt action, even in the slightest, that made her believe that he would cause her serious bodily harm or death. According to the defendant, when she and the decedent woke up, the decedent wanted to drink alcohol. She did not, so in order to distract the defendant, she suggested that they instead clean the defendant's townhome, which they did. It's hard to believe that they cleaned, huh? I don't know, guys. The carpet definitely needed a cleaning. They should have went and rented a carpet cleaner and taken care of that. That would have been a good job for the day. At the conclusion of the cleaning, the decedent, still wished to consume alcohol, so the two of them began consuming alcohol. Yeah, because that makes sense, right? The defendant did not want to consume alcohol, but she did so to placate the defendant. You mean she had to go to peer pressure? Come on, Sarah. I don't think it took very much. The alcohol that they consumed was a Chardonnay bottle by Woodbridge. In order to prevent the decedent from becoming sad or upset, she kept him diverted by smoking cigarettes with him, drinking, enjoying each other's company, perhaps using the dartboard on her porch, and doing arts and crafts and puzzles. Although it apparently would upset the decedent, the defendant suggested he call his daughter, who did not like talking to him when he was drinking, or that he call his brother to tell his brother that the decedent had dragged the defendant down the stairs the night before. Having done these playful activities for numerous hours, there came a point where the defendant and decedent were sitting on her couch in the downstairs living room, and the decedent tagged her and said, "You're it." From past games of hide and seek, the defendant understood this to mean he wanted to play hide and seek. She begrudgingly engaged in this game, as with everything else, to placate the defendant. She ran up to the shower after becoming cold and perhaps some misunderstanding about the rules of hide and seek. She left the shower upstairs and returned downstairs to find the decedent placing himself in a suitcase to hide. At the time of his death, the decedent was only 103 pounds and had a blood alcohol level of 0.138 grams per DL. Do y'all believe that? I don't. He just, and of course he puts him in there. Okay, say he did. Let's just say George put him in there. He didn't zip it up. Here we go. So here's where she talks about it. The defendant saw him doing this and decided to zip the suitcase shut while the decedent was inside it. Because, gee, that's what you do, right? Zip a person in a suitcase. They were both laughing, and there was still no animus between them on this day. The defendant states she did not zip it completely shut. The decedent was able to poke a couple of fingertips through the gap left by the zipper. Yeah, I don't think so. And then the decedent said he could not breathe. The decedent obviously got mad about not being able to breathe. Well, I think most people would. The decedent's getting mad made the defendant get mad. This reminded her of past violence the decedent committed against her, causing her to be unable to breathe at those times. This made her angry. The defendant shook the suitcase. She lost control and the suitcase flipped. She hit the defendant's fingertips with the wooden baseball bat that was in the room. See, the baseball bat was involved. So everyone who said there was a baseball bat involved, you get a thumbs up and high fives for that. Now, after having committed the independent forcible felonies of aggravated assault, aggravated battery, and the non-forcible felony of false imprisonment, the defendant believed the decedent would kill her. Despite believing the decedent would kill her, the defendant flipped the suitcase over so that it was right side up, and she believed the decedent would be able to let himself out. The defendant's specific intent was for the decedent to feel what it was like for her to choke and not be able to breathe. She intended for him to feel like this for 2 minutes and believed that he would let himself out. And when that happened, if she died, she died. Yeah. If you believe that, we could sell you some land in the swamp. She did not intend to kill him, and she did not believe that leaving the decedent in the predicament she placed him in would kill him. His death was an accident. I don't know. We'll talk about that when I finish reading this. Okay. Legal analysis. Battered spouse syndrome evidence is inadmissible if the defense is an accident rather than self-defense. Wagner versus State. The defendant's testimony is that she intentionally zipped the suitcase out of levity and while kidding around with the decedent during a friendly game of hide and seek. Then, When the destined informed her that he could not breathe, she intentionally decided, out of anger, to make him feel like he's trapped in there for a couple of minutes while she beat and shook the suitcase and hit his hand with a baseball bat. This is aggravated assault, aggravated battery, and false imprisonment. She stated that she flipped the suitcase right side up so that the destined could get 2 fingertips through an opening, and she went upstairs to bed, believing he would be able to get out in a couple of minutes. She had no intention to kill him, no intention to leave him trapped inside of the suitcase, and she did not even comprehend that he could die from this. Yeah. The defendant is thus still saying that the destined's death was an accident, and that she's not entitled to an instruction on self-defense or to supplant a self-defense case with reputation evidence, specific instances of past violence, or battered spouse syndrome evidence. The defendant's statement that she perpetually lived in a state of fear of the destined is not sufficient to allow for a self-defense instruction of all the ancillary evidence of reputation, testimony, specific acts of past violence, or battered spouse syndrome testimony. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State. And there's Quintana versus State in there, and Williams versus State. Reed versus State, and Rudin versus State, where the victim hit the defendant with a 2-inch wide, 4-foot long stick in the hand, causing only minor injuries that did not justify defendant's use of deadly force. Comparing the facts of these cases, it is clear that there was not even the slightest overt act by the destined in this case. Prior to the defendant committing aggravated assault, aggravated battery, and false imprisonment, there was no imminent threat from the defendant. State versus Woodson, Morris versus State. You cannot just attack somebody as they walk into their front door and slash their throat with a knife because 2 days prior they sent you a threatening text message. Yeah, I mean, people do that all the time though. Oh, he threatened me yesterday. If this evidence is improperly admitted, it would be a departure from the essential requirements of the law, which would result in an irreparable harm that cannot be corrected by a post-judgment appeal. Roberts versus State. The state acknowledges that the defendant is entitled to change her story yet again, so that if the court does not exclude this evidence now, the defendant should be barred from mentioning battered spouse syndrome evidence until the defendant testifies to something that is a justifiable use of deadly force. Laud versus State. BSS evidence properly excluded from until the defendant testifies when that's the only source of information for the defense. Medina versus State. Not improper to exclude expert testimony until facts are in evidence. Wagner versus State. BSS not available if the defense is an accident rather than self-defense. I certify that a copy hereof has been furnished to James Owens, and this is signed by attorney William Robert J. I was pretty sure that was him. Again, he writes his motions a certain way, much different than Cacciatore. So what do you guys think? This is kind of the first time we're hearing her quote-unquote reasons that she zipped him up in the suitcase. I think it's crap. I think there's truth in here, but I think it's intermixed with her own BS. Again, those who thought that mentioned the bat and her kicking the suitcase, I think we were right on target with that. It's also possible she still kicked the suitcase down the stairs. Maybe the suitcase wasn't downstairs initially. But again, she did beat him in there because, remember, there was no way he had those marks on him before that night. She was called on that during her interrogation. So I think that if she would have done all this, even if she did all those videos, but she would have called the police, he could have been alive. She would have dealt with all the other potential charges listed by Mr. J in his motion, but she would not have been charged with murder. So as far as I'm concerned, she is screwed one way or another. There's not a whole lot of anything she could do. She's going to get up there and she's basically screwed. We already know that. So again, her refusing her plea deal this morning. Yeah. If Owens was smart, he would have advised her to take it. But unfortunately, I don't think that's where he wanted to go. I think he wants to see this thing through to get some publicity off of it. That's just my opinion. Again, some folks may think that he's a great, he might be a great lawyer for her, but I think he's doing it, sort of in a Jose Baez sort of way. But so that's where we are as of Monday, October 7th. I do find the whole all those motions and everything that did come out here at the last second. I don't know if the judge is going to allow any more filings between now and Monday. I suppose that's possible, so I will keep an eye on that if anything big hits it. But I think this pretty much gives us a lot more answers in kind of where we are. She is screwed. That's the simplest way to put it. So let me know y'all's thoughts in the comments. And with that said, I hope you have a great rest of the day. And most of all, stay safe.